Everyone, my name is Shreya Gupta. I am Associate Legal Executive in Haryana Real Estate Regulatory Authority. This video is recorded by my colleague Ms. Bharti Chaudhary. In this video, I will be discussing a very recent case of Punjab and Haryana High Court, that is the Experion developers versus State of Haryana and other related cases. In this case, the constitutional validity of several provisions of RERA were challenged and the court gave a definite order with respect to the issues. Firstly, the challenge was with respect to 43 clause 5 of the Real Estate Regulation Development Act. As per this provision, if any promoter has to prefer an appeal against the decision of the learned authority as well as the adjudicating officer, it has to mandatorily make a pre-deposit before the appellate tribunal. In case it is challenging an order of appeal, the pre-deposit has to be 30% of the penalty or more, or in case it is challenging interest, delay possession or refund, then the entire amount along with compensation has to be deposited with the appellate tribunal as a prerequisite, as a sine qua non for entertainment of the appeal by the appellate tribunal, the Punjab and Haryana High Court. So this provision had been challenged as unconstitutional, arbitrary and discriminatory by the promoter before the Punjab and Haryana High Court. So the High Court observed that the right to appeal is a creature of the statute and it can be made conditional upon the fulfillment of certain compliances by the statute itself, and also appellate tribunal in such a case would have no right to waive the condition of pre-deposit which is inserted in the statute itself. The High Court, in the exercise of its writ power under Article 226, can waive this pre-deposit only in genuine cases of hardship. And with respect to the fact that it was discriminatory between promoters and allottees, the High Court said that this classification was based on intelligible differentia, which had a nexus with the object and purpose of the Act. From the perusal of the provisions itself of the Act, it is clear that the Act imposes several onerous rights and liabilities on the promoters, which is relating to registration, penalty, compensation, interest, whereas very limited obligations have been imposed on the allottees. And therefore, the Act itself has created two identifiable and different classes, and this has nexus with the object of the Act, which is to protect the interest of the allottees with respect to the interest of the promoters. Lastly, it was also said that even if the appeal was on the ground of maintainability, that is on the ground of maintainability of proceedings before the learned authority or before the adjudicating officer, this would amount to hearing of the appeal, and therefore the promoter would be liable to make a pre-deposit under section 43(5), and accordingly the constitutional validity of section 43(5) was upheld. Next, the issue was between the jurisdiction of the learned authority and adjudicating officer. The Punjab and Haryana High Court has put all the conflict and all the conflict of opinion at rest and gave a very definite interpretation of the provisions of the Act and rules in this regard. It has now stated that the learned authority is the one who will decide on the violations under section 12, 14, 18 and 19, that is on any false and misleading advertisements, change in sanction plans, on not giving possession, delay in possession, etc., will decide these violations, and if it finds that there is a violation of these provisions, only then the matter will be referred to the adjudicating officer for compensation to be determined as per the factors given in section 72. And therefore it has once and for all cleared and delineated the powers and jurisdiction of the learned authority and the adjudicating officer. Next, the challenge was whether RERA was retrospective and retroactive in nature. For this, the Punjab and Haryana High Court has relied on the Bombay High Court judgment, that is Nilkamal Realtors. In this judgment, it was held that even though the builder-buyer agreement was entered into prior the coming into effect of RERA, just because the facts are antecedent to the passing of the statute does not make the statute retrospective as long as any action taken under the statute is prospective. So therefore, even if a penalty is imposed, it is not imposed retrospectively from the date of the default. It is only imposed after the coming into force of the act, and no damages prior to that have been given, and therefore the action taken under the act is prospective, and therefore it will not be considered as a retrospective act. So these were the important provisions that these were the important points that Punjab and Haryana High Court discussed, and it's a very landmark judgment that is contributing to the overall jurisprudence of this relatively nascent act. Thank you.